Hi, I'm Jessie Gilbert from the Greenwich office, and I'm going to talk to you today. My title of my speech is Don't Kill the Estate Plan, titling brokerage accounts and other assets to coordinate with the estate plan. So when I got this topic assigned to me, this is the image that bolted into my head. And fair warning, I'm going to have a bunch of Game of Thrones spoilers. So if you haven't caught up, at least for the first few seasons, run away. And if you're not a Game of Thrones person or fan, don't worry, I'll fill you in. So this guy is Ned Stark. And, it's season 1, he's a great guy, a great leader. He's played by the very handsome movie star Sean Bean. And the surprise, spoiler, is he gets killed in the first season. Not even before it's over. And it's horrible, it's shocking. And that kind of shock and surprise is not unlike what has happened in meetings, the first estate administration meeting, and I'm meeting with the family, and we go over the assets, and we start drilling down to see how are assets held and what are the beneficiary designations. And I find out that many, if not all, of our recommendations regarding the title of assets or beneficiary designations didn't happen the way we thought. So I wanted to show you a photo of the last meeting in which this happened. We happened to have a photographer present. This guy, that's the son of the decedent. There's the wife. And that's me. We're all very upset because the plan is not working the way we planned. And that was because something happened between the time the plan was set up and the client passed away. And that was that something happened in connection with the forms of ownership and the beneficiary designation. So I'm going to talk about that today. These are the most common forms of ownership: individually owned, revocable trust owned, joint property, beneficiary designations, and transfer or payable on death accounts. And I'm going to go over each of these in detail except for individual. Individual is simple. It's when something is owned in someone's name alone, and as a result, it's going to go through probate and be available for the client's plan. A revocable trust is kind of, you can think of it as the alter ego to the client. Even if you don't fund a trust during lifetime, it's signed in conjunction with a pour-over will, which takes anything that's individually owned and pours it over into the revocable trust. And it's going to have all of the provisions like Rachel was describing in terms of trust planning, whether for tax reasons or individual reasons. Wills have those also. And so when you want to have a plan work, something has to be in either someone's individual name, so it goes through the will, or in the name of the revocable trust. Now, there are some nuances to that I'll go over. If you don't fund a revocable trust during lifetime, it's kind of no harm, no foul. You're going to lose some of the benefits the revocable trusts offer. Specifically, now assets are going through probate, so you're going to lose the privacy of what's in the estate. There may be some delays associated with probate, especially if it's a contested will. It's much harder to contest a revocable trust. And then assets that go through will, you have to account for all that, and that takes up some amount of time and effort. I wanted to go and really get into detail about the different ways to own property, because there's often confusion about it, obviously, because that's where the trouble can arise. Joint property is like a generic term. So whenever someone says, I own something jointly, I want to know more about that. So these are the 3 most common types of joint property. The first is tenants in common, also often designated by TIC. And that you have 2 or more owners, and each of them owns the property individually. So that if one of them dies, that share, usually it's 2 people, so that half share is going to be in the decedent's name and go through their will and probate and be available for the plan. It will be included in the estate also for tax purposes. Joint with right of survivorship, often designated by, sometimes GTS, GWROS, that means survivor takes all. Survivor takes 100% outside of the probate process. It's by operation of law by virtue of the death of one of the people. And there will be no probate of that asset, but a portion will be included for estate tax purposes. And it depends on who the decedent owned it with. If it's the spouse, it's usually 50% is included for tax purposes. If it's with somebody else, it depends on where the consideration came from. But if it's like, as I often see, a child and a parent the parent provided all the money, it's 100% included in the parent's estate for tax purposes, but nothing's happening at the probate level. And the last one, common one, is tenancy by the entirety, which is a way of holding real estate in New York between spouses and really is equivalent to joint with right of survivorship. So here are the problems with owning joint survivorship property. Rachel described the typical plan that we establish for our clients. We use trusts. We use them for tax reasons. We use them for asset protection reasons. We have generation skipping reasons. And if you avoid probate, if you avoid the will, you're going to avoid all of those provisions. Again, it goes by operation of law to the survivor. And not only will you not end up funding the trusts that everyone spent a lot of time and effort establishing, you can create other distortions. So, for example, if you have something held jointly with one child, but the will says all three children equally, that's not going to match up anymore, right? So the one child's going to get everything by operation of law, and the other kids, first of all, they may not get anything because maybe everything's held jointly with that one. And it can result in really unpleasant tax consequences. So real life story, recently sat down with the clients and found out that a significant amount of assets, real estate and joint property, had a surviving spouse, had a tax-free plan. We're going to do some generation skipping planning and protect the assets for the spouse. And there should be no taxes due. And then I find out there's almost $4 million of assets held jointly with the daughter. And they're going to have to pay about almost $500,000 of Connecticut estate taxes. In this case, we didn't reach, I don't think it's possible. They may also own federal taxes. I don't think anyone expected that. Also, there may be issues where clients say, well, no, I do want this one kid to get that asset and then the rest is equal. But did they mean for that kid to get that asset estate tax-free? What does the tax clause in the will say? Does it say pay taxes on all my assets wherever located, including ones that go to my kids? Well, that means the residuary estate, whatever's left, is going to pay the estate taxes on that joint property that's just going to one person. Some other practical issues, you could have loss of control. What if that kid goes through a divorce? Hello, that's part of the divorce proceedings. It belongs to the child. What if they have creditor problems or go through a bankruptcy? What if they go rogue and take the assets? All of that can happen. Or what if the child dies first and then you have inclusion in their estate by accident? Another way property can pass by reason of death is beneficiary designation. So typically insurance, retirement plans, pension plans, annuities. One thing I didn't put on there, also deferred compensation, stock options, other types of employee benefits. And this is going to start getting redundant, repetitious, but if you have something going directly to a beneficiary, particularly children, does that make sense? Are the children too young? Should that have gone into a trust for their benefit? What if you named your existing children and had some more and didn't add them in? What's going to happen? I don't know. It depends on what the contract said with the custodian. Again, issues with the tax clause. Should there have been something strategic? If you had, you leave your IRA to your kids and your estate to a charity, maybe it should have been crisscrossed And all the same sort of issues that I described with joint survivorship property. I just wanted to mention on beneficiaries, insurance. Always, 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 please, for your clients, review periodically insurance that's supposed to be owned by an insurance trust. As you probably know, in order to keep insurance out of an estate using an insurance trust, both the ownership and the beneficiary designation should be that trust. Just a beneficiary designation will not keep that insurance out of the estate. Be mindful of employer-owned insurance. Just changing the beneficiary to the trust will not keep that out of the estate. You also need to do an irrevocable assignment. Next is transfer on death accounts, and I guess we could also add into that the in trust for kind of accounts. Same sort of issues. Are we going to defeat the plan by avoiding probate and having something go automatically by operation of the contract with a custodian to the client? I had a real life situation. I had a surviving spouse. This client wanted to leave the estate tax sheltered amount, then like maybe $5 million, to his kids, in trust for his kids. We set up the whole plan, got a lot of trustees. We sit down at the meeting. All of his financial accounts are transferred on death to his spouse. It wasn't what we had talked about. Somehow that had happened, and I never saw it, and that's why I call it the hidden threat, because it wasn't lined on the account statements. So we have to be very careful with these things. Now, how does this happen? I think clients often don't fully understand the plan, or maybe they forgot the plan, and then we have helpful people that might, advisors, sorry guys, that say, hey, avoid probate. Why don't you just put your wife transfer on death? Just put your kids joint survivorship. Hold on. Please don't. Please make sure, do your clients a service and make sure you coordinate with the lawyer about the plan. I'm not saying that transfer on deaths or naming kids direct beneficiaries of IRAs are wrong. I just think we have to understand what the long-term ramifications are of doing that, especially if plans are changed periodically. When you change investment advisors or change custodians, it's a good idea to just look at this every few years. And this guy, for those people that don't follow Games of Thrones, this is an undead guy. So that's a zombie, and that's what these plans turn into when we don't coordinate what's going on. So what can we do? So this is Jon Snow, and Jon Snow at the end of one of the seasons died. But guess what? He was revived in the next season by the Red Priestess Melisandre. So can we have that sort of resurrection for a plan? Maybe a little bit. The way to do that would be with disclaimers. Anyone who inherits property, be it through a will or revocable trust, or even certain joint and transfer on death accounts, can disclaim what they would otherwise receive, and they have 9 months to make this decision, and then they're treated as predeceasing the decedent, as long as they didn't accept any benefits and they can't direct the disposition. Then there's a lot of very, very, very strict provisions that you have to follow to the letter to get a disclaimer done. You have to be very careful. I'm not going to get into that because it's just too detailed, but it may be possible to remediate the plan. But it all depends on the asset, because the disclaimer has different effects depending on the asset. So for real estate, if you have joint property with right of survivorship, the disclaimer will change the real estate ownership to tenancy in common. So it'll split it in half, and you'll still have that property available to fund any sort of planning you're doing in your will. And that disclaimed half will be included in the estate. For banks and brokerage and investment type accounts, it all depends on who's doing the disclaiming. If the disclaimant is the spouse, it's going to be presumed that the spouse contributed half, and we can get half into the decedent's estate. If the disclaimant is not the spouse, if they're a child and they didn't contribute any of the money, they can disclaim, and the 100% can go back into the estate to populate the estate plan. For beneficiary designations and takers and transfer on death accounts, it just really depends, once the disclaimer happens, on whether there are contingent beneficiaries. Sometimes they have to disclaim as well. Hopefully disclaim and cascade those until you get it to where you want, which is the estate. So the potential issues with disclaimer, because it's not a home run. What if the recipient doesn't want to disclaim? No, I think that's what Dad wanted, so good luck with those taxes on my share and goodbye. What if the recipient is incapacitated? They can't disclaim. You don't have a power of attorney. You can't get a guardian appointed. Can't do it. What if the recipient has creditor problems or marital problems? That's an asset. They can't disclaim it and defeat their creditors through that. They can't do it. They're going through a divorce. The opposite side's not going to allow it. Maybe the recipient already accessed those funds. Good lucky me. Too late. Can't disclaim. You took the funds. What if you look and, with the transfer on death accounts or the IRA designations, and you've got tier 1 to disclaim, but then tier 2, it's still not the right people, and they don't want to disclaim. You just have to check, because you have to keep on disclaiming till you get to where you want to go. And if you get to a point where it might go to a minor, also very difficult. Who are you to say that you can disclaim on behalf of this child? Maybe that's the best, because you have to think about what's the best thing for them. You'll have to probably go to court and get someone appointed to exercise that if they really if they do it all. So this is my takeaway. Please, we want to coordinate asset ownership and beneficiary designations with the estate plan. We don't always see our clients as often as we'd like. They see you guys a lot more often. Please, periodically review that. Talk to the lawyer. It's important to understand the tax ramifications and of titling something a certain way, or naming a certain beneficiary designation, and please check with us to make sure it's okay. And this is the Stark family in happier times. They were fun, we fixed it all, everything's good, because no one likes unpleasant surprises. Thank you.